The 27 members of the House of Assembly, led by Speaker Martin Amaewhule, have commenced the repeal of the 1999 Commission of Inquiry Law Cap 30 of the old Rivers State. The legislative process was initiated by the lawmakers following the decision of the state government to set up a judicial commission of inquiry to probe the arson and destruction of the local government secretariats during the post-election violence. The commission had invited the Minister of the Federal Capital Territory FCT, Nyesom Wike, and the All Progressives Congress APC Katika chairman, Tony Okocha. Both the minister and the party chairman have shunned the panel. The bill was sponsored by the trio of the Deputy Speaker, Dumle Mole, Lola Puende, and Silvanus Wankwo. Leading the debate on the bill, Wankwo said the laws were repealed and reenacted to reflect the current democratic realities. Other lawmakers who contributed to the debate said it would strengthen the principles of separation of powers and democratic ethos in the state.
I am particularly happy, Mr. Speaker, that this bill will bring us out from the archaic age to the present age, making us one of the legislatures in the states around the country who are trying to upgrade obsolete laws, making laws that are in tune with modern day reality.
Mr. Speaker, as the time this law was made, remember that there was no actual functional democracy. We did not have the democratic principle of separation of powers, where we had an independent legislature, an independent judiciary, and an independent executive arm. The executive was practically doing the job of the legislature and, of course, of the judiciary in most cases. Today, we have a functional democracy with tripartite arms of government. 3 arms of government: the executive, the judiciary, the legislature, doing what they are supposed to do. If we continue to go by this law, Mr. Speaker, it means that we as a legislature are not recognizing the principles of separation of power and, of course, the doctrine of checks and balances.
We are seeking to repeal this law and to reenact the Rivers State Commissions of Inquiry law for the holding of commissions of inquiry and for other matters related thereto. Mr. Speaker, fellow colleagues, the bill in question is brought pursuant to the inherent powers of this honorable House and as enshrined in sections 100, sections 5, subsection 2A, and section 128 of the 1999 Constitution of the Federal Republic of Nigeria, as altered and amended.
Amaewhule said the bill will make provisions for a tripartite engagement between the governor, the assembly, and the commissions to be set up so that powers donated by the assembly were not abused by any individual.
We can have a brand new law for Rivers State, one that reflects separation of powers, one that will pave way for an independent commission of inquiry that will do their job and come up with something that will be good for this state whenever they are given that task. And the good thing is that there is a clause in this bill that calls on the governor to reach out to the assembly whenever the commission of inquiry makes their recommendations, and that the governor should not go ahead to on his own begin to implement all that any commission of inquiry may ask him to do. So what this bill seeks to do is to ensure that the tripartite touch between the commission and the governor and as well as the assembly is ensured for the interests of the good people of Rivers State.
The bill was subsequently committed to the House Committee on Judiciary for further legislative scrutiny.